Good morning, everybody, and thanks so much for having me. It's great to see you all. As Rich said, I have been asked to come talk to you this morning about a small and obscure case that none of you have heard of that's pending in the Supreme Court, but you know, the laughter tells you everything you need to know about that. Everybody has heard about this case. Everybody knows the case that we're about to talk about. But I do want to return back to a couple basic refreshers about the case, because my feeling, particularly living in Washington, is that sometimes the more words get said about a topic, the less anybody really knows what's going on about a topic. So I want to take it from the top a little bit and talk about the two major issues in play, how we got to the court, and what the argument was like, a little bit of a review of the argument. I'm going to give a couple predictions about timing and process. I'd also like to leave time for a couple questions from you all. So please be thinking about any questions that are on your mind that you think I might be able to help answer or at least speculate about. But let me start from the top. The two issues in play at this point are constitutional issues involving the Commerce Clause and the 10th Amendment. So I'll take them in turn. The Commerce Clause, for those of you who need the refresher, is Article 1, Section 8, Clause 3 of the Constitution. And what it says is that Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So we can leave the foreign nations and the tribes out for now and just focus on commerce among the several states. The way that that phrase has developed under the Supreme Court's jurisprudence, it basically means one of three things. It means that Congress can regulate the channels of commerce, meaning things like roads and rivers. Congress can regulate instrumentalities of commerce, meaning ships and cars, And Congress can also regulate other economic activities, meaning wholly intrastate activities, if Congress concludes that those activities substantially affect interstate commerce. And that's the sort of linchpin phrase, of course, that's now come into play. Is the regulation of health insurance via the individual mandate portion of PPACA a regulation of intrastate commerce that has a sufficient impact on interstate commerce to be regulable by Congress instead of the states? So the Commerce Clause, for years and years, decades in fact, was considered to be essentially unlimited. But twice in the past 20 years, Congress has passed laws that have subsequently been struck down by the Supreme Court as sort of hyperextending the Commerce Clause power. And I want to talk about those two cases because I think they give a good platform for understanding what the court may or may not be likely to do with this case. The two cases are, and you probably heard them referred to in shorthand, the Lopez case and the Morrison case. Lopez came out in 1995. And it involved a law that Congress passed a few years earlier called the Gun-Free School Zones Act. And what that law said was, it's a federal crime, not a state crime, a federal crime, to possess a gun within a certain distance of a school. And here was Congress's Commerce Clause rationale for that federal law. Congress said, look, if somebody has a gun near a school, that might increase the chance of violence near the school. And if violence happens near a school, the children might get distracted. And if the children get distracted, they won't learn very well. And if they don't learn very well, they won't get good jobs. If they don't get good jobs, it might affect the economy. That was the Commerce Clause justification for Lopez. And that was Justice Kennedy's recitation of what the majority considered the rather attenuated Commerce Clause connection to possession of a gun within 1,000 feet of a school, I think it was, and a federal crime. So the Supreme Court struck that down. It concluded that that effect on interstate commerce was too attenuated. Here's an interesting coda to that case, though. The Congress subsequently fixed the problem in Lopez simply by requiring that the gun being possessed within a certain distance from the school had traveled in interstate commerce. So that law is still on the books. It's just got one little additional element in it that fixes it with respect to the Interstate Commerce Clause. So that's Lopez. Morrison was a law that was passed, I think, in the late 1990s. The Supreme Court case came out in 2000. Morrison involved a federal statute, a portion of which enabled women who had been abused or assaulted to go into federal court to sue for damages. So it's essentially making a federal civil action out of abuse or assault of women, called the Violence Against Women Act. And what the court concluded was, again, that the nature of that particular federalization of a violent act was too attenuated from the effect on interstate commerce overall to give the court comfort that Congress was actually regulating commerce among or between the states. One thing that might occur to you as you hear about Lopez and Morrison is that both of those cases, which again are the only two cases in which the court has struck down a congressional enactment as violative of the Commerce Clause in the last 60 years or so, both of them involve activities that are essentially state police activities. They are activities that the states are in a position to police against and to enforce and to control. And if you think about, just a quick detour back to the individual mandate, the purposes of the mandate, why it was passed, it was exactly because Congress concluded that the states could not or would not fix the problem that they considered to be epidemic, which is a problem of over 40 million people without insurance. And 40 million, just for those of you who want to do the math, I added this up. That's the populations of the cities of New York, Los Angeles, Chicago, Houston, Philly, and Phoenix. Add all of them together, double it, and then add 10 Washington, D.C.s. That's the uninsured population. And that was the interstate problem that Congress was trying to fix. So that's the Commerce Clause review, Lopez and Morrison, and how this case arguably fits within those or not. Let me briefly talk about the 10th Amendment. The 10th Amendment, of course, comes up with respect to a different constitutional challenge. This is with respect to the Medicaid portion. I don't need to educate you about what Medicaid does. You know it's a joint federal-state program. You know that it is partially funded by the federal government, partially funded by the states. What PPACA did, among other things, was that it substantially expanded the Medicaid sort of entitlement within a particular state. And for the first several years after passage of this act, federal government offered to pick up, or is picking up, 100% of that new expanded coverage. But soon that percentage will drop. I think first it drops to 95, then it drops to 90, and I think thereafter it's not clear. So the question is, what happens if a state declines to accept the extended coverage? And what essentially happens is that the federal government it may not, but it certainly has the power to, withdraw all federal funding from that state's Medicaid program. The reason this is a 10th Amendment issue is because the 10th Amendment says the powers that aren't expressly reserved to the federal government are reserved to the states. And their argument that the challengers to this particular provision of PPACA are making is, you can't compel us by wielding that strong of a monetary tie to engage in this expansion of Medicaid. That is simply too compulsive under the 10th Amendment. The response is that the 10th Amendment is designed to preclude the federal government from compelling a state to do something, but that this is just a monetary quid pro quo. It's a massive monetary quid pro quo, but it's one that involves a simple decision by the state whether to accept the federal money in exchange for incurring certain obligations under Medicaid or forego it. So that's the way the 10th Amendment issue is set up. Let me jump ahead and just give a quick review of where the Court of Appeals cases came from. There were 4 of note. Very quickly and in order, they were the Fourth Circuit, which is located mostly in Richmond, Virginia, but also hears cases from the surrounding courts, surrounding states. The Fourth Circuit was the first decision to issue with respect to all of these constitutional challenges. And what it did actually was fascinating, because everyone was watching and waiting to see whether the Fourth Circuit would rule the individual mandate unconstitutional or constitutional. The Medicaid issue was not in play. And what the Fourth Circuit did was to check the third box. The Fourth Circuit concluded that it did not yet have jurisdiction over the constitutional challenge to the individual mandate because of something called the Anti-Injunction Act. And it's early, and you are not fully caffeinated, So I will spare you a long recitation of the Anti-Injunction Act, but suffice to say that there's a law that precludes any of us from challenging a tax before we are taxed. And the Anti-Injunction Act was found by the Fourth Circuit to apply here because, importantly, the Fourth Circuit concluded that that penalty that somebody has to pay if they don't get insurance under the individual mandate was essentially a tax. Maybe not close enough for it to be justified under Congress's taxing power, but close enough for the jurisdictional preclusion to kick in. So the Fourth Circuit sort of went off in a whole new path. The Sixth Circuit was next. The Sixth Circuit concluded, 2-to-1 decision, that the individual mandate was constitutional. The reason this is important, among other things, is that one of those two in the majority, to the extent that you're playing ideological sort of poker with who's lining up where, one of the two in the Sixth Circuit majority is a relatively young judge named Jeff Sutton, who was appointed by the second Bush. Jeff Sutton wrote a very compelling concurrence supporting the constitutionality, at least under a certain type of challenge, of the individual mandate clause. So that was sort of point one of interest. Next came the 11th Circuit. The 11th Circuit went the opposite way, 2-to-1. Found the individual mandate unconstitutional. It's lining up essentially like a perfect law school exam to get everything up to the Supreme Court. Two judges found the individual mandate unconstitutional. The Medicaid issue was in play in the 11th Circuit. And what the 11th Circuit Court of Appeals concluded was that the Medicaid expansion did not violate the 10th Amendment. It was perfectly within the government's prerogative to expand Medicaid and to condition federal funds on states accepting the expansion of Medicaid. Last but not least, after petitions already had been filed in the Supreme Court, came the D.C. Circuit. And the reason I mention it is, again, because of an unusual alignment of judges. The D.C. Circuit sits only in D.C., and its judges split, again, 2-to-1, but the two in the majority finding that the individual mandate was constitutional were a Carter appointee named Judge Harry Edwards and a Reagan appointee named Judge Lawrence Silberman. Judge Silberman and Judge Edwards gave the government a particularly hard time during the oral argument before the D.C. Circuit, and I say that with meaning because of what I'm sure you all have heard about the Supreme Court argument. But suffice to say, sometimes judges give lawyers a hard time and then end up ruling for them, as two judges did in the D.C. Circuit. Judges Silberman and Edwards found the individual mandate constitutional. A third judge, Judge Brett Kavanaugh, who was appointed by the second Bush, brought the sort of doctrinal wheel full circle and concluded, just like the Fourth Circuit did, that the Anti-Injunction Act barred the challenge right now until somebody forewent insurance and paid the penalty and then challenged it as a tax. So that was the layout when it got to the Supreme Court. The Supreme Court took the 11th Circuit case, the case that came out of Florida, the case that found the individual mandate unconstitutional. It's holding those other cases, the Sixth Circuit, Fourth Circuit, and D.C. Circuit. It's holding them in reserve. It's not doing anything with those cases until it figures out all of the issues in play in the Supreme Court. Let me talk briefly about the arguments. And I think it's hard to come and to talk to you about the oral arguments after all of the pundits and reporters and TV talking heads and columnists have already offered their view. But I will say this, the government, in its perspective, has a series of paths that it can offer for affirmance. And the question is, which of those paths is going to find the most favor with the most people, essentially? So if you were to have listened to the argument, if you were to read the transcript, I think what you will find is that the government's lawyer, Don Verrilli, the Solicitor General, was essentially offering different footholds for different justices. And depending on what he was hearing back from the justices, he was altering his presentation a little bit to maybe make a little bit more of that particular avenue and less of another. That's why when Mr. Verrilli, General Verrilli, was criticized after the fact for being somewhat nonlinear in his responses, I actually think that's a relatively facile comment, because the reason that General Verrilli was offering the lengthy responses was essentially to give the justices a menu of choices. Choices about how they could go about affirming this, choices about what language they could use in affirming the law. The challengers, as often is the case, have in some ways an easier path. There's one path to reversal. Strike the thing down. It violates the Commerce Clause. That's a relatively easy rhetorical road to walk, and Paul Clement walked it very, very well. But the interesting interplay I want to focus on is between Chief Justice Roberts and General Verrilli, and subsequently Mr. Clement, and Justice Kennedy, naturally, and General Verrilli, and subsequently Paul Clement. Because what you saw with those two justices, whose votes I think are in play, is a testing of certain parameters of each side's argument. What you heard from the Chief Justice when General Verrilli was arguing was questions about essentially the limits of his argument. He asked, for example, would you be making the same argument if you were trying to require everyone to have a cell phone? Because cell phones could be very useful in the event of an emergency. No one knows when emergencies are going to arise, which of course is a phrase that's been used to describe the need for health insurance, because no one knows when you might need health care. So the Chief Justice's questions to General Verrilli early had to do with sort of testing the understanding about what this particular defense of the individual mandate could otherwise contain. Could it also enable Congress to require you all to buy cell phones? Justice Alito chimed in and said, could this also require all of us to buy burial insurance? And General Verrilli's responses homed in on a particular point that I think caught some favor with the justices, and that is what Congress established here was that unlike cell phones, unlike burial insurance, unlike broccoli, and I'm not eating broccoli anymore after all of the conversation about broccoli, after the requirement to lose weight or go to unlike the requirement to lose weight or go to a gym or any of those sort of high-pitched bumper sticker rhetorical devices. What you have here is a market that has been severely, profoundly compromised by the use of the healthcare system by people who are simply not able to pay for it. The market has been compromised, and the payment obligations have shifted to hospitals. They've shifted to other payers. They've shifted to individual policyholders. That is a market arguably unlike any other. And what you heard General Verrilli doing in response to all of these sort of hypotheticals of different stripes was to return to that core concept. General Verrilli essentially disclaimed Congress's ability to regulate cell phones, burial insurance, goodness knows broccoli, gyms. And what you heard him trying to do, particularly again with Chief Justice Roberts and Justice Kennedy, was to assure them that this was not the kind of holding that was going to constitutionally transform the Commerce Clause. Let me also focus on Justice Kennedy's questions to Paul Clement. Justice Kennedy, for good or for ill, for better or for worse, has been identified as the nation's swing justice. As Justice Kennedy goes, so goes the case. I actually don't think that's quite true in this case, but his vote is important. His vote was ardently courted in the party's briefs. And what you heard from Justice Kennedy early and late reveals the depths to which his vote still might be in play. His very first question must have struck a chill in the hearts of anybody hoping that this law was upheld, because Justice Kennedy's first question to General Verrilli out of the box was, can you create commerce in order to regulate it? Now, that, of course, is a profound, arguably a profound overstatement of what Congress was doing, because Congress was regulating the healthcare market. It was doing so by way of, among other things, the individual mandate. But that was Justice Kennedy's first question to General Verrilli. But his very last question to Paul Clement was actually more of a statement. And I don't have it here, so I don't know it verbatim, but I've thought about it long and hard enough. he said something to the effect of, when you have a situation where the people, the young people, the healthy people who are outside of this market are uniquely proximately able to influence that market, what result does that cause? And I think what you heard Justice Kennedy doing there, also in service of some of the questions that he asked General Verrilli, in service of Chief Justice Roberts testing the waters with his different hypotheticals, was trying to figure out, is there a way that this decision can be written narrowly enough so that we explain this is a unique circumstance. This is a circumstance where everybody is in this market, whether they know it or not, whether they want to be or not, whether they are in need of health care right now or not until tomorrow or the day after tomorrow. So that swing from his very first question to his very last, I think, was hugely, potentially significant. So after setting it up that way, though, what I would caution is that I think a lot of the pundits who make their livings doing this assign a certain amount of kind of almost Talmudic significance to the questions the justices asked. There's question counting that goes on. Justice Scalia asked 17 questions of General Verrilli and only 11 of Paul Clement, so that must mean his vote is lost, and so forth. The truth of the matter is that oral argument is very much just the tip of the conversation. The conversation, for example, continued immediately after the close of the 3 days of arguments in this case, when the 9 justices, and only the 9 justices, sat in a room together, and starting with the most junior justice, Justice Elena Kagan, each spoke their minds about what they had heard over the previous 3 days of arguments, and each of them, ending with the Chief Justice, offered their initial view. That dialogue continued, presumably for quite a long time that day, and then it continues after the opinions are assigned. The opinions will be assigned by the Chief Justice if he is in the majority. The opinion will be assigned by by the next most senior justice who is in the majority if it is not the chief. And the dialogue goes back and forth during the writing of the opinions. And I'm saying opinions because the one thing I feel comfortable guaranteeing you is that there will be at least 2 opinions. This is not going to be a 9-0 win one way or the other. So, the caution I would leave you with is, I think it's hugely interesting and very engaging to listen to the arguments and to opine on who might have walked away the victor or the vanquished in that particular moment, on that particular day. But the dialogue about these cases and the constitutional underpinnings of them extended well before those arguments and will extend well after it. That's one of the reasons why I wanted to lead with what the Commerce Clause cases actually say, because speaking on behalf of, as one of the lawyers who represented the AHA in amicus briefs in the Supreme Court and in the courts of appeals, what I can tell you is, from my perspective, having looked at those decisions, this is a Commerce Clause case unlike the other 2 that have undertaken to strike down provisions. And no matter what the rhetoric that was employed during the oral arguments, I feel that these justices will go back and will relocate the constitutional bases for their decisions one way or another in the case law, not in the sort of sign-waving people who were standing outside of the court. So why don't I stop there, and if there are any questions, I'm happy to take them. I find it impossible to think that I've satisfied your every question.
You've answered all the questions. Thank you very much.